The Constitution, Chapter 4. Now we will look at our very first source of law. In this chapter, we're going to discuss the structure of federal government, how to interpret the Constitution, powers of the federal government, and the limitations on federal power. The Constitution is our written document that established the structure of our federal government. It was written in 1789, and it created a central government that's supposed to address national concerns. The structure. In Article 1 of the Constitution, the legislative branch is created. The legislative branch is the branch that is empowered to make laws. Article 2 establishes the executive branch, which is the enforcer of the laws. And then Article 3 established the U.S. Supreme Court, the judicial branch, which interprets the laws. Under Article 3 in the Supreme Court, lower courts have been created. The only court specifically mentioned in the Constitution is the U.S. Supreme Court. Let's look at the relationship of the federal government to the states. In order to understand this relationship, you need to look at the history of the forming of our country. The original 13 colonies had acted almost like autonomous countries. They printed their own money, they had their own militias, and they transacted business between themselves and Britain and Native American tribes, and then sometimes amongst the different colonies. But they always thought of themselves as autonomous units. Then, in order to overthrow the British, the colonies came together and worked as sort of one unit in order to push out the British. But after the War of Independence in 1776, initially the colonies went back and reverted to acting autonomously, as if they were independent countries again. And they just decided to pass the Articles of Confederation in order to kind of have a loosely governing body, but there was no strong central government. Well, they quickly realized that that did not work, and so they came together to form the Constitution, where they decided to create a national or central government. They wanted this national government to address issues of national concern. For instance, declaring war. But the colonies were very wary of trading one dictator, the King of England, for another. So initially, they were not in favor of having a strong president or a strong executive office, and they didn't want the federal government to have too much power. This is important. It's important to understand that the states really felt that they were agreeing to cede power to create a federal government. But whatever they did not expressly delegate to the federal government, they intended to reserve to themselves, to reserve to the states. So this structure is important for you to understand because often in our political discourse, you hear the notion of states' rights versus a growing or intrusive national government, if you will. This has its roots in the fact that in our country, the states originally had all of the governing power. Then they came together and decided to delegate some powers to a national government. So they gave up some power to create this new entity, the federal government. And that is why states believe and hold that whatever we haven't actually expressly given to the federal government in the Constitution, we reserve and still have the authority to do. Alrighty, so that's where this notion of delegated powers comes from. Those powers that are expressly written in the Constitution, particularly in Articles 1, 2, and 3, creating the federal government. That those are the powers that the states have delegated to the federal government. These are the things you can do, federal government. If it's not in this document, you can't do it. Shared powers, these are areas in which the states agree to share power with the federal government. A prime example of shared powers is the power to tax. Both the federal government and the state governments tax individuals. Then we have a notion of police powers, which is broader than the term police, but it's the power to enact laws that protect the general welfare, health, and safety of the people. And typically, police power also resides in the states. Now, there are some laws and statutes that have been passed by the federal government that would seem to regulate, health and welfare of people. For instance, you can think of lots of the regulations that are put out by OSHA, which is a federal administrative agency, the Occupational Safety and Health Organization, which is regulating how work conditions, so to protect workers. So you might say, well, that's kind of exercising the police power. But as we'll talk about in a minute, the federal government is sometimes able to regulate areas that normally are reserved for the states if the area they're regulating somehow affects interstate commerce or affects some other area in which the federal government has express power. So we'll talk about that. Now, this all leads to this notion of we've got federal powers, we've got state powers, sort of parallel, right? The federal government only has the power to create laws in the areas that it has been delegated in the United States Constitution. If it starts passing laws in areas that exceed its authority, people could argue, or litigants can bring a case trying to challenge the constitutionality of a statute, and they would argue it's unconstitutional because within the Constitution, Congress doesn't have that power. So that's a lot of times the crux of the argument. When you hear that some portion of the Affordable Care Act that was passed during the Obama administration, when people argue it's unconstitutional, they're not saying that the law itself has a bad intent. They're not saying necessarily we don't think that people should have health care, but although that might be their thought, but the root of the argument is federal government, you don't have the power under Article 1 to make such a law. If the states want to create health care for their citizens, they can under their reserved powers or under their police powers, but health care has nothing to do with the powers that are explicitly enumerated in the Constitution for Congress. That's how that argument works. So we're going to talk about, we're going to look specifically at what are the enumerated federal powers. And we're going to talk about this doctrine of federal supremacy. And this is an important key doctrine, and it's something that I want to make sure you remember and understand. So we're going to talk more about federal supremacy. What does it mean? The quick rule is federal law preempts conflicting state law. But what does that look like? So we're going to take a look at that. Let's first look at the express powers given to the federal government in the U.S. Constitution. There are two primary powers that have been delegated to the federal government by the states, and they are the commerce power and financial powers. So let's look at that. The commerce power is found in Article 1, Section 8, Clause 3 of the Constitution, and it reads, Congress has the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Those are the three groups. So Congress is going to be the entity negotiating and creating law about trade agreements between the United States and European countries. Congress has got the power to create laws that regulate how business is conducted, that is transacted interstate, i.e. among the states. and Congress has the power to regulate commerce with the Indian tribes. This is expressly given to Congress. This is a delegated power. The states, in other words, have given up the right to create laws in these areas, and they have expressly given it to the federal government. Initially, early in the country's history, this clause was interpreted very narrowly. And what I mean by that is that when a law was passed by Congress attempting to regulate some area of commerce, and if someone had brought a case opposing it, the U.S. Supreme Court read this statute very narrowly and said that literally Congress could only make laws that affected interstate commerce with the states. If it wasn't interstate commerce, they couldn't pass the law. Well, that interpretation began to change, and the U.S. Supreme Court began to say, well, among the several states does not actually require pure interstate commerce. As long as the conduct being regulated, i.e. the law being passed to, remember we talked about law, you could think of law as principles that govern conduct. So if there was a law that was talking about how business is being transacted, and the business being transacted, it at least affected interstate commerce, might not have been in interstate commerce, but it affected interstate commerce, then the courts begin to say, you know what, that's all right too. That's okay, that's still constitutional, that still fits within Article 1, Section 8, Clause 3. Now our Supreme Court is becoming a little more conservative and swinging back more towards the middle, and is saying that laws created by Congress in order to be constitutional, fit within this section, have to be regulating the underlying conduct must be related to some sort of commercial transaction. It can't merely just affect commerce. It's got to have some underlying business transaction occurring. And this came up in a challenge to the Affordable Care Act because it was challenged as being unconstitutional because for a number of reasons, but one of them being that the federal government lacked the power to create a healthcare system, and specifically that there was a provision in the Affordable Care Act that required that everyone purchase healthcare insurance. And so the Affordable Care Act was challenged on the bounds that there is nothing in the Constitution, specifically Article 1, that gives Congress the power to make people buy anything. You can't make people buy anything. That's not one of the delegated powers in Article 1. So that challenge actually was effective, and that portion of the Affordable Care Act was struck down by the U.S. Supreme Court in that they said that Congress lacked the power, i.e. it was unconstitutional, lacked the power to require citizens to purchase things. Now, if individuals were purchasing things, Congress could regulate the purchase if it affected interstate commerce, but Congress didn't have the power to make someone go out and purchase. Congress also has, in its second important power, financial powers. Now, these financial powers often work in tandem with the commerce power, and the financial powers are often how the federal government is able to regulate areas that you might not think they have the ability to do. For instance, so financial powers of the federal government, they have the ability to tax, they have the ability to spend, and they have the ability to create a national banking system. So how does this work? Now, we just mentioned federal government has two main powers, to regulate interstate commerce, and then these financial powers. Almost everything else is reserved to the states. So how does the federal government, for instance, encourage or persuade states to do things that it wants them to do? Like how does it get the states to adopt laws that they don't really have to? Financial government, uh, the federal government often uses its ability to spend money as a carrot. So states, if you adopt our regulations in an area, if you would like to have more funding for your schools, you will do X. Because on its own, the federal government might not have the ability to create any laws as they relate to schools, because schools are a completely intra-state activity, local concern completely. But local Greensboro City, school board, if you'd like to receive federal funding to help supplement your budget, you will adopt the following provisions. For instance, you will sign on to our No Child Left Behind Act. Even though that act that was passed had to do with education and trying to create a minimum floor of learning for students, that there is nowhere in the Constitution does it give the federal government the power to regulate education. Now, the government might be able to somehow argue that education affects interstate commerce, maybe, or they can just create standards and guidelines and encourage states to adopt them by offering them the carrot of money if they would sign on and implement the federal guidelines. And that is what happens a lot. Because the federal government's actual delegated power is very narrow, commerce power, financial powers, and then this ability to declare war, which obviously doesn't occur a lot if we're lucky, right? We're fortunate. The federal government then has very little delineated areas in which it can regulate. So it uses its ability to regulate interstate commerce because almost everything we do now affects and impacts interstate commerce, because almost all businesses and so much of our conduct, and if you're a company making a product, almost all businesses sell their products interstate and also probably internationally. And so to the extent that almost all of our business activities are interstate and international, that is how the federal government can easily pass laws that regulate how we conduct business. That's easy to do. The harder areas to reach are things that really affect people, individual welfare, education, health, and services, things that really do impact people's lives, but really take place on the local level. So when the federal government wants to try and get states to adopt change in those areas, they have to usually use the power of their purse to give incentives to states and local bodies to want to adopt federal regulations or federal laws. Now, we've got these areas in which the federal government exercises power. And the two I really want you to think of about are commerce powers and financial powers. Well, remember, the states have a huge amount of power. Whatever they have not expressly delegated to the federal government is still reserved to the states. However, in those areas where the state has delegated power to the federal government, the federal laws in those areas are supreme, take precedence over state law. This is the doctrine of federal supremacy. If you have a federal law and you have a conflicting state law, the federal law will preempt conflicting state law. Now, I want you to think about that. Federal law preempts conflicting state law. So you've got two conditions that are required there. First, the federal law has to be in an area that the federal government is empowered to act. It has to be relating to commerce or one of its financial powers. If it's outside of that area, then the state law might be able to proceed and they could get the federal law struck as unconstitutional. But if a federal law is relating to an area in which it is empowered to act, commerce, financial powers, and then there's a state law that seems to run afoul of that federal law or is similar to that federal law regulating the same area and is in conflict with that law, it will not be able to stand. Where there is a direct conflict between state and federal law will prevail. This is the doctrine of federal supremacy. So let's look at an example. Congress enacted the single state registration system. Single state registration system. We're calling it SSRS for truckers, and it's so the single state registration system allows a trucking company to register in one state, fill out one set of forms, and it will be recognized in every state, right? So hopefully you hear in that description of that law, that sounds like an area in which the federal government can regulate, because they are passing a law about how truckers who conduct interstate commerce have to register. So it's a single state registration system for truckers, allowing them to fill out a registration in one state and it'll be recognized in every state. So sounds like the federal government has the power to do that. But then the state of Michigan has a statute that requires truckers operating vehicles in their state to pay a registration fee of $100. So any truck company that comes through Michigan has to pay $100 in order to use their roads and transact business. The American Truckers Association sues Michigan over its statute. I hope you can think of why. Why would they do that? Well, first of all, the reason they're going to do it, right, is they're going to say, well, wait a minute. We're already paying a registration fee under the SSRS system. And we complied with this federal statute, which says if we register, and I'm sure they had to pay money for that registration, that we have to register, and we can register once and it's good everywhere. So when Michigan comes up with their own additional registration for trucks who are going through the state, that costs truckers extra money, and it's also inconvenient in that what if the truck is just going through Michigan on its way to Illinois? But they are subject to this law and could be fined. So that's why they are going to want to challenge this and say, Michigan, you can't pop up and add more cost to this, to our business. The federal government has already passed a law. We've complied with it. This is all that's due. So the first thing I want you to think about is who would be bringing the lawsuit and where would they bring it? Who would the parties be? So we're going to have the American Truckers Association sues Michigan over their statute. So the plaintiff would be ATA, the American Truckers Association, versus the state of Michigan. Now, it could be the Michigan Transportation Department or some subsidiary who has actually, issued this statute or regulation. But we're going to, since we don't know a lot more about the details, we're going to say the state of Michigan. So if it's the American Truckers Association suing the state of Michigan, alleging that their state law conflicts with federal law, what court would we bring this case in? Have you thought of it? It's going to be in federal district court. The plaintiff, ATA, will file their complaint in federal district court. Why? Because this case falls into the subject matter jurisdiction of the federal courts. It is a case alleging the violation of a federal law. The state registration statute is in direct conflict with the federal law. So this raises an issue or a federal question issue. This is a question of whether or not federal law has been violated. So what would be the result? You've got the Michigan registration statute in direct conflict with the federal law saying you can register once. Result, the SSRS is going to preempt Michigan's conflicting trucker registration law due to the concept of federal supremacy. Now, interpreting these laws, interpreting whether or not the commerce statute is being violated in this case, interpreting whether or not the Michigan state law actually is in direct conflict with the federal single registration system. Who does that fall to? That falls to the judiciary. And the judiciary has a couple of ideologies that they generally follow. How do courts interpret the laws? This is a really big topic. When you hear, usually in the news, particularly around the time when you have presidential elections, you will often hear people saying that I'm going to look at who the president will appoint to the United States Supreme Court. That is always a big issue during elections because many people are really concerned about who's appointed to the U.S. Supreme Court. So you might want to know, okay, well, why are they concerned? What's the big deal? Federal judges, as we talked about earlier, are appointed by the executive branch, which is typically the president, with consult from his advisors, and they are appointed for life, at least. And what we want ideally is to appoint judges who are fair and unbiased and who do not hew to political ideology, but who decide cases on the facts. But even if we have neutral judges, they typically will fall into one of two ideologies about how to view the Constitution, and that impacts how they may rule. And so those two main views or ideologies are the bedrock view and the living document view. The bedrock view is an approach where judges sitting on the Supreme Court, when they are faced with the question of whether or not a law passed by Congress is constitutional, they look to the original framers' intent. They try and put on the hat of what did the founding fathers intend when they wrote Article 1 back in 1789. Because they want to try and adhere to the original intent of the Constitution and not expand it, not necessarily view it in today's terms. They want to look at what did James Madison and Hamilton and John Hancock, and what were their original intent. That's the bedrock view. Now, when you view the Constitution in that manner, typically what you're going to do is, this is also considered a conservative view, conservative in the sense that you do not want to broaden the power of the federal government. You are trying to keep the power of the federal government small and narrow in expressly what's put in the Constitution. Remember, we talked about earlier in this presentation, if you think about the history of the forming of this country, the states did not want another king. They didn't want to create an American king. They wanted a relatively weak national government that would only do what they expressly told it could do. And so jurists who take that same approach, who think we should have a small federal government, will tend to also be of the bedrock view, because that's where that kind of comes from. It's that the small government is what was laid out originally by the framers. And so most of the laws and most regulations should come from the states, not the federal government, we're going to construe the Constitution narrowly. Narrowly means, in other words, if it's not written in the document, we're not reading it into it. So that's the bedrock view. And that's conservative little c, not conservative as to political parties, but conservative in that we're not going to broaden things. We're going to be we're going to be very cautious and not expand what this Constitution means. Sort of on the other side of the spectrum is the living document view. So judges who view the Constitution as a living document, they view the Constitution as a framework for our principles that must be viewed in the context of contemporary times. Like it has to grow and kind of be seen through, what the original framers intended, but how would that be played out? What would that look like given our current context? So people often associate judges who take a living document view as judges who are liberal, who tend to, and if you are considered to be a liberal judge, who take a view of the Constitution as to what makes sense now, what does fairness or what does commerce mean today, as opposed to what it meant back in 1789. Those judges are often accused of making the federal government larger and bigger and giving more power to the executive. That's how that's viewed, because if you're a living document jurist, the critics would say that living document jurists tend to find that the federal government has more power than the Constitution actually states. We can all debate about that, but I want you to know that that is typically what people are associating with these terms. So when you hear politicians argue for states' rights, that's part of a whole litany of things. States' rights, they're going back to that original history where all power resides with the states. They only came together and delegated a few powers, commerce, financial, war, to the federal government. Everything else belongs to the states, so it's their business and they should be the ones in control. When you also hear states' rights arguments, that often tends to associate with it, we want conservative judges who will not expand the power of the federal government. So those arguments tend to go together. So we've talked about what the federal powers are. We know that if we have a federal law that falls into an area that the federal government is empowered to make laws, commerce power, financial powers. If there's a conflicting state law, the federal law is going to be preempt and prevail over the conflicting state law due to the doctrine of federal supremacy. So you might wonder, well, are there any limitations on this federal power? Is it unfettered? No, it's not. So we've got several checks on federal power. Where do we find them? Of course, in the Constitution. In the Constitution, Articles 1 through 3 set up our structure of government. Article 1 in particular, empowering Congress to make laws. But the founders were smart and realized that when people have power, they tend to abuse it and may exceed it and like to try and grow it. And so they also included in our Constitution checks on the power. Now, I will say that most of the checks were put into the amendments of the Constitution. Those are the additions that were made afterwards. So it's sort of, you could think of it as later they realized, wait a minute, we better put some checks in here to make sure the executive and judicial don't get out of hand. So they weren't in the original articles, but within the amendments, there are limitations on the federal power. And the three main delineated ones are due process, equal protection, and the Privileges and Immunities Clause. And then sort of in the background, you could also argue that the Bill of Rights, which includes, particular individual rights in amendments, 1 through 11, that are secured to the person, that you could argue that those are also checks on the federal government. Because, for instance, you've got the First Amendment, the right to free speech. Well, maybe you might not think that's a limitation on federal power, but if you have the right to freedom of speech, we know that creates a corresponding duty in the government to allow you to exercise your free speech. So it can operate as a check. The Bill of Rights, the individual rights secured to us as citizens, also act as a check on federal power, because when our individual rights are violated by the government, we can sue in federal court, saying that their conduct is unconstitutional. So that's just generally always available to you. But let's look at specifically due process. Due process is found in both the 5th and 14th Amendments. In the 5th Amendment, it makes due process applicable to the federal government, and the 14th Amendment makes due process applicable to the states. The due process is a limitation on federal power because it prohibits the government from depriving any person of life, liberty, or property without due process of law. So you cannot lose your life, you cannot be imprisoned, put in jail, which kind of covers both life and liberty, or have something taken from you without due process of law. Now, does this mean it can't be taken from you? No. What this means is that there's a process that must be followed, i.e., this sounds like a procedural law. It means, now, due process of law, we don't have you can look in the back of your book and read the full clause. Due process of law is not actually defined in the Constitution. So this is another example of, if you think back to our mother with the curfew rule, even though we have the words here, government may not deprive a person of life, liberty, or property without due process of law, there's no definition for what due process of law means. So someone had to bring a lawsuit and challenge this conduct when the government was trying to take something and say, wait a minute, what does due process of law mean? What does that require? And typically due process of law, through case law issued by the courts, which has become precedent, means that you have to have a hearing. First of all, you have to have notice of a hearing, then the hearing and the opportunity to be heard. So essentially a trial, but it's not always a trial. But you have to be notified that you are in jeopardy of losing your property, or liberty, and you have to have the opportunity to be present and to put on your side of the issue. Does it mean you'll win? No, you're not guaranteed that this won't happen, but you're guaranteed you get this chance to make your case. That's what the due process of law is. And that's at a very high level. Procedural law. Doesn't mean you'll win, but they have to give you the process first. Equal protection, made applicable to the states also. So this applies to both the federal government and the states. Equal protection. This guarantee prohibits the government from treating one person differently from another when there is no reasonable ground for classifying them differently. I want you to notice the caveat here. No reasonable ground. So we do not have an absolute right to equal protection, to all be treated equally. We do not. We have a right not to be treated unfairly if there's no reason to do it, if there's no good reason for being treated differently. If the government can assert a good reason to treat people differently, then they can. So with the law, it is always important to read every word, because equal Protection Clause states that the government is prohibited from treating people differently when there is no reason to do so. If they've got a reason, they can do it. Privileges and immunities. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. What does this mean? This means you can't be treated differently in different states. You can't go to Georgia and have them act as if you're not a citizen of the country and act like, oh, this is Georgia. We don't want North Carolinians here. Get out. Now, might it happen? Yes. Have people been treated unfairly because they were new to the state or new to the place and the local folks didn't know them? Yes. But what this clause says that if the government does it, i.e. the local government passes a law or affirmatively treats you unfairly just because you're from another state, you can sue to enforce your right. And I want you to think about this throughout the course. When you have laws about conduct, just like rules that parents make, it doesn't mean because there's a rule, everyone will abide by it and there won't be any trouble. What the law provides is a method to get redress in case someone does violate it. It doesn't stop people from treating people unfairly or violating your rights. It just gives you a method, a way to go to court because you've got now a source of law and your case would be actionable where you could pursue some, damages in case they do violate your rights.